Good morning, all of you. So last week we discussed about patent, and you have got an idea that patent protects what. So now, can somebody tell me that what are the criteria required for an invention to be patentable? To get a patent, what criteria invention is required, and what is the procedure that the government or some particular patent office adopt to get the patent, whether it is a examination based system or simply registration based systems, or what are the say based on those answer, again can you analyze that what are the drawback of the existing patent systems, and further what are the different emerging issues that have been coming in respect of invention and its patentabilities, also ethical issues and technological the space with technology development have been occurring, all those aspects. Okay, so let's on those backdrop I will discuss today before going to actual discussion on another protection mechanism for invention, that is utility model. Before going on that part, I will try to give an overview of the different emerging issues in respect of patent, then how you can apply this utility model with reference to few of them that you will understood. Okay. So now let us say emerging issue with reference to the patents, that let us say patent with reference to the life form, means whether life form can be given patents or not. So when I discuss the patentability criteria in India, then I have told you that naturally occurring microorganism is not patentable in India. So if you genetically engineered a microorganism, that can be patented, but not naturally occurring microorganism. So this is the issues with reference to the patentability of the life forms, and I already told you that USA they told anything or everything under the sun made by man can be patentable, and you have you should read that Diamond versus Chakraborty's case that regarding the patentability of oil eating bacteria. Similarly, another case in Indian context, that AG case, controller versus AG case, that is regarding that patentability, whether patentability of microorganism, or we can consider the bacteria. So regarding the life form patentabilities, the issue with reference to that, let us say whether I can produce a sheep or goat having higher meat value by genetic engineering process. You may heard about the Dolly patents, that case incident, and regarding different discussion with reference to that. Okay. So issues with reference to the ethical and other sorts of issues with reference to the life form and patentabilities. Then patent with reference to the within the life form, you can consider the gene. Patentabilities of the gene can be also an issues, and with reference to that legal and ethical issues with reference to the gene and patentability. Generally, structure sequencing structure and sequencing SQ. Let us say structure and sequencing patentabilities with reference to the DNA. Or DNA patentability, structure sequencing patentability. These are the emerging issues with reference to the biotechnology. They are legal issues and patentabilities issues, and the procedural issues means regarding the examination part, how it will be examined, whether patent search database is inappropriate. All those issues are there with reference to bio part. Similarly, I already discussed with you software the issues are coming up. Software per se is not patentable in India, and software with reference to the technical contribution can get patent in AP, European countries, and similarly US they give patent on business methods also, patent on business methods also. So those are the different issues are coming with reference to the patents, and these are the emerging issues with reference to the patent. Okay. So similarly another issues are coming up nowadays. You know that embedded system or say structure SoC system on chips, that the life of the system of chips or softwares are very these areas have been growing very fast, growing very fast. So the problem with reference to that, the life forms of those technology is very short, and the now patentability is, for the reason I was telling, the patentability criteria to get a patent, all sorts of things, whether they will really meet that all sorts of criteria of patentability, that is another issues, and whether and the time frame to get a patent is another issues, and the long time of protection of the patents is another issues with reference to system on chips and software. Okay. So these are the few of the emerging issues that you should be aware of those kinds of situation, just like say software and patentability. So what will be the appropriate protection mechanism of software? So I am here system on chips or say SoC. Sometimes we refer that, and its protection mechanism, whether the patents will what are the lacuna in respect to patent protection of SoCs, and similarly for as a software per se. Similarly structure sequencing, DNA structure sequencing and patentabilities and IP protection mechanism is issues, and life form patentabilities, all those kinds are the various issues. So biotechnological issues, domain issues with reference to biotechnology, electronics. Similarly these issues are already resolved, nano and patentability. So initially issues with reference to nanotechnology patentabilities was also there, regarding the patentability criteria, regarding 3D of our Indian Patent Act, whether it is a discovery or invention or mere discovery or invention. Those are the issues with reference to nanotechnology was also there. Okay. So these are the few issues that have to be addressed or have been addressing by various forum or research paper or judicial forum. Okay. So that are the different emerging issues that I want to mention you as before going to the just like utility model part. Now that like in the beginning I have asked you a few questions, that like say whether patent the criteria, you know that novelty, inventive steps, and say capable of industrial applications, and that is the definition of invention. But the problem with reference to that criteria of patentabilities means, let's say basically the criteria, second criteria, that inventive steps, the second criteria of patentability means inventive steps, just like say criteria of patentability we may consider inventive steps. Inventive steps, I already told you, there lies the problem, that what are the problem in respect to inventive steps, that say solution should not be problem. If you follow problem solution approach, then solution should not be obvious to the person skilled in the art. If you follow TSM approach, that teaching, suggesting and motivating, that prior art should not teach, suggest and motivate the person in ordinary skill to do the to ultimately formulate the invention whatever you are trying to claim. So the means that your invention should have sufficient leap over the knowledge of ordinary person or average knowledge of the person skilled in the art. Sufficient leap means sufficient leap over the knowledge of persons skill in the art. Knowledge of person skill in the art means person skill in the art means person having average knowledge, person skill in the art. Sometime we call posita, posita, skill in the posita, in the art, posita. So who will be the posita? Posita different case state that average person having average knowledge in that field. So should have, let's say sufficient leaps, let's say X leap. So now the problem with the X leaps, X means sufficient, although that will be defined case to case basis. But if somebody have come with say a delta X improvement over the knowledge of Poshita, then whether he will be denied some rights over the delta X improvement. Okay. So, this is the one questions that whether the X and delta X, you understood delta X is radical improvement or incremental improvement over the knowledge of the Poshita, knowledge of the person skilled in the art. Then another problem I told you that that whether they will be denied the question. Then let us say technological improvement is happening so fast, but patent procedural aspect suggested you should get a patent. It would take at least minimum time to get patent. Time to get patent, it is required at least 3 to 4 years, depending upon the jurisdiction. At least 3 to 4 years are required to get a patent, except in respect of express provision. Express provision also at least you will also have to wait for 3 to 4 years. And also there is issues with reference to that. Means you do generally do you have a rights from the date of filing, or also date of maybe from the date of publication, but the issue with reference to the legal title, whether your legal title means you will really get the legal title during the stages of prosecutions by means of so legal title or equitable title, that is the issues that. So, a time frame to get the patents. And third, the technology life cycle, life cycle. So, few technology the life cycle is very short. So, 3-4 years if the technology have to wait to get some rights by virtue of some patent, then the problem like that time technology may be we consider obsolete. So, these are the few issues that maybe with reference to that patent, maybe we may consider these are the maybe the drawback with reference to the patent protection of invention or specific invention. So, considering all those aspects, so now there is a say another tools, or say sometime we consider the forms of protection of say intellectual creation is available in the form of utility model, or sometime we call innovation patent, or sometime we call petty patent. So, all those things try to protect somehow we can consider have tried to take care of the drawback whatever I mentions. So, like the drawback means whether incremental invention, or say time to get patents, or technology life cycle. So, those are the drawback with reference to that patent systems. I cannot say really a drawback with reference to the societal means let us say balance between the owner versus society, but let us say if I consider those are the drawback with reference to the inventor side. So, why not to give some sorts of protection in respect of delta X improvement. So, all those kinds of things lead to the another forms of protection that are we are telling that utility model. I am writing here utility model, or some countries they call it petty patent, or innovation patent, or just like utility model or utility patent. US they sometimes call utility patent, utility model patent, utility patent. All those things try to give protection with reference to try to take care of those features whatever I mention maybe within the purview of drawback of the existing system, specifically with reference to the say technology which have been moving so fast, just like say a consider software. And also some cases the improvement may be also so delta X improvement, with reference to the code and its applicabilities. So, that lead to that another forms of protection just like utility model, protection, petty patent, innovation patent, and utility patents, just like USA, they call it utility patents. They denoted by U. When you search, say USPTO, they denote utility patent also there. Utility patents is also there. Okay. So now, what it is, you got little bit an idea why say utility model or petty patent or innovation patents. Just like a country like EU, Australia, they call it innovation patent. Some country they call it petty patent. China, they call it utility model protection. US utility patents. So the history or jurisprudence suggested it has started from Germany to give protection with reference to the incremental innovations, and say subsequently it has been adopted in other countries. Okay. So that's the jurisprudential aspect or historical aspect of the protection mechanism for incremental invention. So when we are discussing about the invention, so another mechanism, just like say you may consider the protection of the protection of the say invention. So invention can be also protected by means of these sorts of tools depending on the country to country. So now let's say I have given an example of, let's say, the gear assembly here. So gear assembly is a product. So now some radical improvement with reference to the gear teeth arrangement and others, that by virtue of that that in arrangement may be novel. So arrangement of the gear teeth, little bit change or delta exchange of the gear teeth. By virtue of that, you are generating a novel gear system. So definitely it will be considered novel. But definitely it has also application in industrial process. But maybe whatever improvement you are making, that may be considered may be considered obvious. I am telling may be considered obvious, or may not have sufficient leap over the knowledge of the people having the knowledge of the people in that field. So why to give a protection for that kinds of situation, then that utility model will be the important tool. So just like say a recent study indicating like China, they have been utilizing the utility model very well, because for SMEs and just like say SME specifically, and so that company who don't have to invest much, they may go and take this route for protection of this type of invention. So now criteria what have been set for. So we may consider now utility model also protect invention. Okay, but invention, whatever the invention definition we got it for the patent, here the invention definitions is different. Just like say novelty will be there, because as a gear teeth arrangement you are changing, that is novel, means that type of arrangement is not available in the prior art. Then now the issue is that novelty, when we discuss with reference to the patent, we have criteria of novelty with reference to somehow we can consider is a absolute kinds of novelty. So here also novelty criteria may differs from the country to country depending on the utility model protection mechanism. So a few cases we can follow the mixed novelty with reference to publication and use of those kinds of device or system in that country. So novelty criteria may be referred compared to the novelty criteria may be referred with reference to that invention regarding the patentability. Then major important difference is this one, that less stringent or no inventive step criteria. So invention to get an utility model protection may few cases do not require inventive step criteria, few jurisdiction where petty patent and innovation patents. Okay, then or less stringent, say delta X improvement, just like so don't require to judge with reference to the posita and all sorts of things. So less stringent inventive step criteria, so easy to get easy to get meet the patentability criteria with reference to the inventive steps. Okay, then less stringent examinations procedure. Okay, just like you know that when I discussed with the patent prosecution or patent procedure with reference to that India, I referred that what are the different milestones, just like say first filing, then publication, then pre-grant opposition, then AFR, then acceptance, then post-grant opposition, all sorts of things require time. So, few cases just like say here that few cases they follow or registration, they get registered, then subsequently examine few country, or say they some cases the examination procedure is less stringent, that they don't go by the examination procedure followed for patent. So, for that reason less stringent procedure of granting the utility model, so people will be more attracted to take that route for protection of incremental invention. Okay. Then less time period for protection, just like a patent protection is available for 20 years irrespective of any field of technologies, just like say you told that if I consider biotech invention, if I consider software along with embedded system related invention, all are getting protected for 20 years, but if I consider the with reference to the investment, with reference to technological progress, just like how much investment you have to be made, you have to made with reference to that for development of single API or a drug or drug or API, basically for biotech or pharmaceutical related invention. Same type of investment may not required for your software related invention. Okay. So, software related invention, so understood that. Okay. And also another part that is for let us say for drug, again you have to when required to drug to put in the market, you have to again follow the another, you have to comply with another regulatory bodies criteria, drug controllers. So, then approval from drug controller, then only you can put that thing in the market. So, some cases that return on investment, to get return on investment with respect to drug or pharmaceutical research required more time, but with reference to the software you can consider not much, means I can say that not the investment may be less compared to the whatever investment you have to do for an API or pharmaceutical invention, including process or product. Okay. So, and also life cycle of the software, you understood that have been changing rapidly, including communication device and communication protocol, all sorts of things. So, unnecessarily 20 years monopoly right provided to an patentee may block others people to use that invention for other purposes. So, whether that lead to the some sorts of market inefficiency, that the questions lies there. So, and also less time period for protection. So, there lies the issues innovation patents. If I give less time period of protection for the less stringent examination procedure and less stringent inventive step criteria related invention. So, for that reason generally they country to country for utility model or petty patent or innovation patent, they protect for 7 to 10 years, say 7 to 10 years period have been provided to protect that this type of invention, which invention will come through that utility patent model or utility patent or innovation patents or utility model protection. So, less time frame have been provided because considering that like technology progress rapidly, life cycle is less, and also let us say give some sorts of exclusive right for at least 7 to 10 years for that incremental invention to attack that incremental invention and invention. So, they are allowing that utility model protection, although India do not have till date utility model protection, considering that let us say till ordinary person skill in the art to make the radical improvement or say incremental improvement and use it, considering that is a public good. Okay. So, less time period for protection, easy to obtain because few country I told you that they just register, then examination may do, subsequently they examine. Some cases they may in some cases they examine, but not following the stringent requirement. Then I already told you it protect incremental invention, that some incremental with reference to increment with reference to increment with reference to an invention can be protected by means of that utility model part. Then it is a maybe useful for SME. I already referred, it can be useful for SME. So useful for SME, just like I already told you the definition of invention with reference to utility model for USA, that issued for invention of a new and useful process, machine, manufacture or composition of matter, or a new and useful improvement thereof. New and useful improvement of a process, machine or manufactures or composition of matters may come within the purview of utility patents in USA. Okay. So let's see, you got an idea that why I discussed this this thing to you, because for technologists or engineers, sometime during working specifically you do lots of improvement or modification. Improvement or modification, that improvement and modification can be an intellectual property if utility model type of protection mechanism is available in India. But the question lies there whether this type of incremental invention will ultimately create social or market efficiency or not. That's the that their research required to be carried out, specifically considering the social economical situation in India. So if I ask you now with reference to software, whether this type of mechanism will be useful. Okay, just like I told you that software per se is not patentable in India. Software means software as such is not patentable, but you know that software is having say some sorts of software is useful software, just like say definitely when you incorporate software that generate a useful process, just like a sensor algorithm or sound system algorithm or emergency algorithm is generating a useful process. Okay. And I told you that and software that judging the inventive steps and also novelty part, very challenging task that with reference to judging the novelty and inventive steps part with reference to software. So software examination challenge, and so then whether we can go for this type of mechanism for protection of software, say that's the questions I'll put before you. Just thought about how can you apply this type of mechanism with reference to the software. Similarly, say embedded systems and others areas or somewhere the technology have been progressing so fast, whether 20 years period of protection is enough or not, that now we have to thought about it. So now let's summarize. So I was discussing about the utility model. I have told you different few emerging issues with reference to that. Patent protection, just like say software, life forms, then DNA structure sequencing, express structure sequencing, all those things. And then I tried to give an idea about the another form of say intellectual property protection, say protection mechanism in the form of patents, or just like utility patents or petty patents or innovation patent that have been in practice in different jurisdictions, including Australia, Canada, Germany, China. As we are considering this IP in the purview of cross jurisdictional aspects also, so you should have knowledge with reference to the cross jurisdictional practice and methods also. Just like say if somebody asks me whether utility model protection available in India, whether I can go and file utility model utility patent in USA or not, I will say definitely you may have to take permission following. But 39, the question lies there, 39 is applicable for Patent Act. So whether it will be also applicable for utility part, there lies. But I think we have to take permissions from government for filing the utility patent. That part. Okay. So I say just like ending it here for with reference to the utility model part. Okay. Let's read all those kinds of things and we can further discuss those elements.